Okay, so next up, we have the lawyers. I love lawyers. I am one, that is true, but I still love my water lawyers. We've got a dream team that is going to give us a current legal issues update. So I'm going to welcome to the stage Shauna Fitzsimmons Sledge. She is a partner at SledgeLaw. Emily Rogers, she's the managing partner at Bickerstaff, and Madison Huerta, who's an associate at Lloyd Gosselink. These three have this one covered. They're going to kind of self-moderate. Thank you for making me not moderate another panel. And thank you, Neil, if you're still in the room, for not getting a stomach bug last night and texting me that I needed to moderate your panel too. So I am going to turn it over to Shauna to kick this one off.
Okay, thank you, Leah. Good morning, everybody. Thank you for sticking around. Clearly, Leah saved the best for last. Y'all are in for such a treat. So while there haven't been any or too many, recent huge controversial groundwater cases like we've seen in the past with Day and Bragg, our panel has worked together to identify some current legal issues or trends that we're seeing play out in the court or legislative system, and I think will continue to be hot topics and should be on the groundwater community's radar. And those topics include exhausting administrative remedies before filing suit against the GCD, a few trending issues in energy that may impact groundwater include produced water and geothermal energy, and of course the ever so controversial bed and banks, use of groundwater in bed and banks and discharge permits. So we talked about that actually a lot this session, so that's nothing new to most of y'all in the room. So with that, I'll have, Madison kick us off with getting us up to speed on the few groundwater cases we have seen recently, which deal with exhausting administrative remedies and filing suit against the GCD in state court and in federal court. So take it away.
All right. Well, good morning. It's wonderful to be with you all and wonderful to be on a panel with Emily and Shauna. So my name is Madison Huerta. I'm an attorney with Lloyd Gosselink Law Firm in Austin, and I have the pleasure of speaking with you guys about the riveting topic of exhausting administrative appeals. But this is really an important topic. So why are we talking about it? Oh, can you hear? Oh, that's just for your... Oh, perfect. Thank you. So why are we talking about it in the last panel at this conference? And it's a really important issue because exhausting administrative remedies really acts as one of the final bridges, if not the final bridge, a plaintiff has to cross before they can sue a groundwater conservation district. And like Shauna said, there are a few recent cases that we felt it was important to share with you all. But before we dive into that, I want to take just a moment to kind of talk about the background of this doctrine and why it's important in Texas. I think it will help all of us understand what the courts are considering when they're analyzing these issues and what the attorneys involved are arguing. So the doctrine of administrative remedies is a longstanding principle of administrative law, and it requires a party in an administrative proceeding, like a hearing before a groundwater conservation district, to wait until that proceeding is completely finished before filing suit in district court. And I've provided a few reasons why this is important, but I really want to focus on two. First, it ensures compliance with district rules and procedures, so it prevents someone from circumventing the rules that you've put in place and going straight to district court. And then second, it respects the delegation of the legislature's authority to you all as subject matter experts that regulate this resource and get to make decisions about that regulation. And the legislature, let's see. It's the green one. Oh, thank you. Perfect. The legislature has agreed that this is an important requirement, and they've codified it in two separate places that are relevant to us. The first is Section 2001.171 of the Administrative Procedures Act in the Government Code. And the second, and most important to us, is Chapter 36 of the Water Code. So Chapter 36 expressly requires that before you can sue a groundwater conservation district, you have to exhaust all administrative appeals. And the district's decision has to be final. Seems simple enough, but when is a decision final? And the answer to that is really, it depends. It depends on the type of hearing, whether it's a contested case hearing, and whether SOA is involved. And I've provided a few statutes that provide a little more guidance on that issue. But the biggest takeaway is that if it's a decision, it's depending on the type of hearing. And when there's a contested case hearing, you have to file a motion for rehearing to exhaust administrative appeals. So depending on the hearing, you don't always have to, but if it's a contested case hearing, you do. And the Austin Court of Appeals affirmed this decision in NDOP versus Meyer, which was a 2018 case that gave us a little guidance. And in this case, the court determined that the landowner that was appealing the decision of a groundwater conservation district in a contested case hearing had to exhaust their administrative remedies by filing a motion for rehearing and waiting until the decision on that motion for rehearing was final. So in this case, the court determined that the landowner that was involved just filed their suit in district court too soon. So that's really the background and the framework for this issue that kind of leads us into our recent decisions on this matter. Okay, so Cockrell Investment Partners versus Middle Pecos Groundwater Conservation District. If you're thinking this case sounds familiar or you've heard it before, it's because you likely have. We're on the most recent decision was the third iteration of this case. More recently, the fourth and fifth case have been filed. But here, as an NDOP, here Cockrell, as an NDOP, filed their suit too early. And they were disputing a permit-related decision. But they filed their first two lawsuits too early, like I said, before its requests for rehearing were denied, and consequently, before the district's decisions were final. In its third lawsuit against the district, and where our most recent decision on the issue comes in, Cockrell sought prospective relief to prevent the district from renewing this permit or making this decision again. And again, here the trial court dismissed the suit on these jurisdictional grounds. And that was that Cockrell didn't properly exhaust administrative remedies by filing a request. Well, they did file a request for rehearing, but then ultimately waiting for a decision to be made on that request for rehearing. So that's where we are with the Cockrell cases. Like I said, there's 4 and 5. That third decision I just spoke about is currently at the Court of Appeals. So we're waiting to see how that court will ultimately apply that statute, if they'll apply it in the same way they've been applying it, or if they'll kind of differ from how they've been applying it and how the trial court applied it in this case. And there's one other exhaustion of administrative remedies case pending at the Court of Appeals that Emily will speak to a little bit further, but this is the LCRA in Lost Pines case. And like an NDOP, so there's the merits of the case, but as far as procedurally, like an NDOP, this involves a permitting decision at the Lost Pines Groundwater Conservation District. And there's a question that's being argued of whether the plaintiff observed the finality timeline applicable when a case is referred to SOA, like what happened here. But here, unlike some of the previous cases, the trial court did not apply the law that was established in NDOP that I touched on at the beginning. So NDOP's lawyers are involved in this case, and they're arguing that NDOP should apply. Our firm's involved in this case, as well as Emily's. So that's kind of one to be on the lookout for to see, will the court take this issue into consideration, and will there be a determination on this case that provides us a little more guidance on this issue moving forward.
Sorry.
And then just finally wrapping up, so one other case that's really relevant is Vanderpool Management versus the Bandera County River Authority and Groundwater Conservation District. And this case looked at the same issue, but in federal court rather than state court. And so it kind of begged the question, how will the federal court look at this? Will they consider it in the same way that the state court does, or will they do something differently? And here, Vanderpool filed suit in a federal district court while the contested case hearing was still pending at SOA. And this suit that they filed in district court alleged a takings claim, an equal protection claim, and a due process claim under the U.S. Constitution. And they thought that because there was a recent Supreme Court case that said you did not have to start a takings claim in state court, you could go straight to federal court, that maybe they didn't necessarily have to exhaust administrative remedies in the same way. But the district court ultimately agreed with the district in this case and said, sure, maybe you don't have, or not maybe, you no longer have to file a takings claim in state court to get it to federal court, but you still have to exhaust administrative remedies. And in this case, there was a pending contested case hearing going on, so you have to go back and finish that pending contested case hearing before you can file suit in district court. And so just to wrap this up in a few seconds, really where we stand with this is that I can't necessarily provide an answer to this issue at this point, one definitive one-size-fits-all answer. But what we can do is look at some of the cases that I've discussed today and some of the cases that have already happened to see, well, where were remedies exhausted properly? Where were they not exhausted properly? And kind of look at our facts, and that'll provide us some guidance moving forward. We can also look to these two cases that I've mentioned, LCRA as well as Cockerell, to see what decisions they make on that. But like I said when I started, exhausting administrative remedies is a really important issue for districts. It can kind of be that final bridge that has to be crossed before a district can be sued. And in doing that, I think this requirement really protects groundwater districts and really protects the authority that the legislature has delegated to you all as experts, as regulators of this resource. And it prevents someone from being able to dismiss that authority or to circumvent that by going straight to district court before fully going through the rules and the procedures that you've put in place.
Thank you, Madison. Emily, you've been involved in some of these cases. Do you have any strong feelings about exhausting administrative remedies?
Of course I do.
I figured.
I will say in the LCRA case, it's a little bit different in that there was a motion for rehearing that was filed and granted. Mm-hmm. And so then a second motion for rehearing was filed and denied. And so what we're really talking about is what's the timing? When do you have to file, and then when can you file suit? And then do you have to refile the case, or can you amend your petition? So those are the issues that are out there, and it's pending now in the Third Court of Appeals with briefing due. So obviously we think we did it correctly, but everyone has their opinion. I think it would be, you worry about those kind of gotchas, mm-hmm. and Chapter 36 is just frankly not clear. So
yeah, I think the lawyers in the room that have worked in groundwater law and in litigation have had to deal with not just exhausting administrative remedies, but other procedural questions and pleas to the jurisdiction that we've seen, trying to sue districts not under Chapter 36, but perhaps under the UDJA for attorney's fees. We've seen courts make decisions on that front. We're seeing people sue districts in federal court also for takings claims rather than state court. So a lot of these procedural questions are out there because groundwater litigation is a fairly new area of law, and I think that this will continue to play out in the courts. But this is a really dorky, interesting question of exhaustion of administrative remedies for us lawyers.
So I bet y'all are really happy you stayed for that.
Okay, moving on to very interesting things. Do I have the thing? Okay, I can't really see this guy. Okay, legal issues and energy, starting with produced water. I'm going to cover this topic. We're seeing, as many of you know, produced water, geothermal energy are emerging issues that could potentially affect, groundwater quality, groundwater ownership, groundwater regulation. So looking at produced water first, many of you may be interested to know that produced water is not actually defined in anywhere in statute. In the Natural Resources Code, it is included in the definition of fluid, oil, and gas waste, but that also includes salt, brine, frac fluids, and other produced fluids when you produce oil. So we basically, or I guess historically, let me back up. You really have to grasp how much produced water there is being produced with oil. I think there's about 7 barrels of produced water produced with 1 barrel of oil. In 2019, there was 3.9 or 3.8 billion barrels produced just in the Permian Basin alone, and that equals 168 billion gallons. So we're talking about a lot of water. And these operators historically had nothing, this water was useless, and it was basically a liability and needed to be disposed of as quickly as possible. And that was done through Class 2 injection wells. As many of you will recall, Class 2 injection wells started causing problems in the Barnett Shale and the Permian Basin. These earthquakes were happening, and the Railroad Commission started really cracking down on the permitting of Class 2 injection wells. So this led operators having to seek new disposal methods or alternative methods of reuse. So it was in 2019 when we really saw the legislature and other folks talking about incentivizing oil and gas companies to treat and reuse the produced water. We saw a couple of bills about tax cuts, and those bills ultimately didn't pass, but a bill that did pass is House Bill 3246 by Darby. And that bill clarified that any party that takes ownership, or I guess possession of fluid oil and gas waste, aka produced water, to treat it for subsequent beneficial use has title over that water. And this could have been for 2 reasons. It could have been because we were starting to see that there could potentially be value in this water. And then I also think because we weren't able to dispose of it and we were gonna have to do alternative means of discharge or reuse, operators were selling it to third parties and they didn't want the liability attached to it. So also that session that's not included on my PowerPoint is another bill that was really important that transferred the permitting of produced water and other oil and gas waste discharges. It transferred that from the Railroad Commission to TCEQ. So because of these limited opportunities for Class 2 wells, injection wells, the big play now that really needs to be on everyone's radar is that operators or third parties taking over this water are wanting to discharge oil and gas waste into creeks and streams and now aquifers, which I'll get to in a minute. And while, we've heard folks at the legislature and, TCEQ commissioners talking about, come to us, we'll work with you on this. And I'm all for that. I don't know if CJ's in the room, but I'm not anti-produced water. I just think that it's important for us to know what is actually getting discharged because there's a lot of chemicals, known, unknown, in this produced water, including frac fluids, that the TCEQ has not set MCLs for. So there's a lot we don't know, and it's going to be a lot harder to fix these water quality issues down the road once that that waste is already put into the water. And this is happening in other states like Pennsylvania. So something that's pretty big that needs to be on everyone's radar. 2021, we had, of course, SB 601. The Produced Water Consortium was created by Senator Perry. Chairman King and Chairman Perry also worked together on another bill that session, House Bill 3516, which directed the Railroad Commission to adopt expedited permitting rules to encourage oil and gas waste recycling for beneficial purpose. So this is basically for commercial produced water recycling operations. Funny enough, the Railroad Commission has not proposed rules on this yet, but last week they said they were coming out any day now, so we'll keep an eye on those. And then this session, 2023, we saw more produced water legislation pass. Senate Bill 1047 by Chairman Perry, as Brian McMath discussed in detail yesterday, Part 2 of Senate Bill 601 in 2021. This just basically added pilot projects or one or more that the Produced Water Consortium will report on in a year, and as well as provided the Produced Water Consortium $5 million to work towards that effort. So probably one of the biggest bills y'all will care about that passed this session is House Bill 4856 by Darby, which appears to authorize the injection of treated fluid, oil, and gas waste into freshwater aquifers for recharge. And I think TCEQ might have a harder time with this one. Same concerns that go for fluid, oil, and gas waste discharges into creeks and streams, go for, injecting this into aquifers under Class 5 injection. So we'll just want to keep an eye on this. I'm not sure how EPA feels about this under the Clean Water Act. I think this could potentially be beyond TCEQ's grant of authority under EPA, and so we'll want to work really closely with them. I know our groundwater district clients will be commenting on those rules and probably working with TCEQ staff just to develop those rules. So in recent years, we have had some really wonderful advancements in technology in many parts of the state to treat produced water, and is often sold now for a profit, usually for reuse within the oil and gas industry. And so this has led to the issue of who owns the produced water. And for the first time, we had a case about a month ago, I think it was January 28th. This opinion was issued by the El Paso Court of Appeals, which is just a 3-person panel. So there were 2 that signed the majority opinion, and there was 1 dissent. And before this case was issued, I would have said there are probably equal camps of folks that believe produced water is part of the surface estate, which is traditional. The groundwater is part of the surface estate. And then a handful of folks, which I would assume oil and gas industry would believe produced water is part of the mineral estate. And in this case, this landmark case, which I'm sure will go up on appeal to the Supreme Court, this case, you basically had the operator, the oil and gas operator, COG operating, leased the mineral estate, but had 4 leases between 2004 and 2014, and it was a totally plain just grant of oil and gas and other hydrocarbons. No talk of any water, produced water, nothing. And then the operator, COG, started selling the produced water. There was a market for it in that area. So after they're already selling this produced water, Cactus Water comes in and signs I guess it was a lease with the surface estate owner getting the produced water. And Marty Jones represents Cactus Water. So he made I read all the briefing on this, and he made some really great points. But at the end of the day, the majority, COG is the one who sued, saying we have the exclusive right to this produced water. And at the end of the day, the majority of the court opinion said that it hinged on whether produced water, as a matter of law, is waste or is it groundwater. And they determined, based on the statutory language, that it was, in fact, waste and therefore could not be groundwater. The court also looked at the fact that produced water had always been a liability for the operators. And so therefore, when these leases were executed years ago, when there was no market for produced water, it never could have been contemplated that there would have been a reservation of it in the lease. And then finally, the court said, and we don't favor implied reservations. Well, the dissent went out and said, you need to look at the plain language of the lease, and there's no, inclusion of produced water, and therefore in the mineral lease, so therefore it's part of the surface estate. So we'll see how this plays out in court, and I think it will be a really great case to watch. And these are just some quotes from the case that I found extremely interesting. Oopsie. Okay, geothermal, real quick. Geothermal energy, I don't know, did any of y'all see the geothermal presentation yesterday? Because that was super, super interesting, and this makes my little a cartoon look like a joke. So there's apparently, as we all heard yesterday, if you attended that session, which was awesome, there's a big push for geothermal energy in Texas. And we saw that this legislative session, just like we started to see this push in 2019 for produced water. And a lot of my questions were answered yesterday. There's basically a number of factors at play here that are making Texas ripe for the utilization of geothermal energy and basically for geothermal power and power plants. So these are much deeper wells than the open loop, closed loop wells you're seeing here, and much more complex, but you get the idea. Open loop, most of our GCDs would consider open loop utilization of groundwater and open loop not domestic use, and then to the extent it's discharged or injected, then that would be considered waste. So generally speaking, those are not very favorable. And then closed loop, most of my groundwater districts don't regulate those at all. However, we have seen in some districts, like in Barton Springs, a lot of problems happening with the drilling of these closed loop wells, and so there is an exception there. This session, we saw geothermal energy ownership. A bill was passed specifying that geothermal establish ownership by a landowner of the geothermal energy below the surface of the landowner's land. It's part of the surface estate, which I think is interesting that produced water would be part of the mineral estate when the geothermal energy is much deeper than produced water, but we might talk about that another time. And then it also transferred a component of permitting for closed loop wells from TCEQ to the Railroad Commission, and I think they're just, who doesn't want their permitting at the Railroad Commission? I mean, let's be real. So I think we see what the writing on the wall here. We're trying to expedite this permitting process and make it easier to get these permits for these type of operations. So, do y'all have anything to add to that? A lot of information.
I think you covered. I mean, you definitely covered it. I have a question for you. Senator Perry had his water consortium bill, and then they put more money into that this session. Do you think the legislature will continue to have an appetite to work on these issues, or is it up in the air?
1,000%. I think this is a huge priority for Senator Perry, and I think he even mentioned yesterday, he alluded to the case I just went over and said something along the lines that this is something they're going to be looking at during the interim, and so maybe it will produce water ownership will be an interim charge. And I can expect it to be I would expect it to be in the interim report. And so I think this will continue to be a priority on both of these fronts. But we didn't really see that much geothermal energy go through these water committees, with the exception, did we, Sam? No, these went all through the energy resources. Yep. So these kind of like came on our radar pretty quickly. Leah and I had a lot of discussions about these and what are they trying to do, and so we'll see how this plays out. But it was really pushed by this new-ish alliance, Geothermal Alliance something, and I saw a list of all the members of that alliance yesterday, and it made a whole lot more sense, which was basically a bunch of startups and then all the major oil and gas companies. So I think that's going to be the next big play. Okay, and sorry, are you ready for yours?
Ready.
Okay.
Do you have the clicker?
Yes, ma'am.
We'll get started.
Dead.
Gonna have to put these on.
All right, and Emily is going to talk to us about bed and banks permits.
So the first thing I wanted to do when we talk about this is just kind of outline what the issue is, and then give you the legal lay of the land, so to speak, so we're all talking about the same law and what's out there already. So the issue is the transport of groundwater pursuant to a TCEQ issued bed and banks permit considered waste under Chapter 36 of the Water Code? So just so that we're all on the same page, there's only one exception. With one exception, all water that enters a water course becomes state water. And when it becomes state water, then it becomes regulated by the TCEQ pursuant to its surface water rights permitting program. For groundwater and return flows, though, wastewater return flows, the TCEQ can issue a bed and banks permit And when it issues that bed and banks permit, it effectively keeps that water from becoming state water. You've got a permit and it's going down the stream in its own little slice. It's not mixing with the state water. So the other thing that we need to look at is Chapter 36 and the definition of waste. And it's willfully or negligently causing, suffering, allowing groundwater to escape into a river, creek, natural water course, etc. Nothing in this section talks about evaporation. I'll just make a note of that. Then I want to mention these other provisions that when we consider whether or not transporting groundwater in a water course is waste, we need to look at several sections in the Texas Water Code. That's 11042C, which specifically is about the bed and banks, using the bed and banks to transport all other water that's not contract water or that's not your return flows, wastewater, groundwater-based return flows. And when that section was adopted, there is some language in the legislative history that mentions that provision was put in place in part to address transporting groundwater. There's 2 notice provisions that require TCEQ to provide notice of when it issues a water right or a bed and banks permit that where groundwater is used as an alternative source of water. And then I want to mention 4 cases that address or talk about using the bed and banks of a water course to transport groundwater. And that's the Corpus Christi versus Pleasanton case. That's from 1955. In the Kickapoo Land Company case, there a landowner was using the bed and banks of a water course to transport water. And then it's also mentioned again in the City of San Marcos versus TNRCC and the Day case. So that's really all we have to go on about whether or not, to determine whether or not this issue of transporting groundwater is in fact waste. So last fall, the TWCA, Texas Water Conservation Association, put together a subcommittee that was going to look at this. And what we did is to kind of address this issue, one bit of information was to know what the groundwater districts were doing. And what we found out in going through and looking at all the rules of all the groundwater districts across the state was about 50% of the GCDs don't address this issue at all. Their rules are silent on it. There's 4 GCDs that affirmatively allow groundwater to be transported via water course. About 10% expressly prohibit it, period. No transport in a water course. You have 25% of the GCDs that place some sort of limit on transporting groundwater. Either you can only transport it, 1,000 feet, or it has to remain on your property. So there's some sort of limit there. And then all of those areas where there's not a GCD, TCEQ is issuing permits left and right, allowing the discharge of groundwater into a water course, then to be using their bed and banks authorization that allows them to pick it up later. So that kind of gives you an idea of where we're kind of all over the board here about whether or not using the water course to transport groundwater is allowed. And so I just want to point out some other considerations. No case since the Corpus Christi case has addressed whether or not, has considered or addressed the definition of waste. And there is no case that addresses the transport of groundwater via water course that involves a groundwater conservation district. We do have a PFD out of the LCRA case that we've just mentioned about the administrative exhaustion issue. That case, there was a question about whether or not you could transport the groundwater in the bed and banks. And the ALJ in that case found that transporting groundwater via the water course was not waste if LCRA has a bed and banks permit. Ultimately, that issue was moot because LCRA had amended its permit application to restrict the transport to Travis County. And it's really hard to use the bed and banks of a water course to transport water from Bastrop to Travis County. That's upstream. So it just really became a non-issue in that thing. And then also in 2022, it's actually the 2023 House Natural Resources Report, recommended some amendments to the water code. Basically, that report recognized that, transport of the bed and banks is not necessarily inherently bad, that there are areas that where the losses to evaporation are not all that great. So particularly East Texas, your transportation losses may not be very high percentage-wise. And there's some efficiencies to be had using, the bed and banks rather than, spending financially a large pipeline. Using a bed and banks might be more efficient. And the streams could possibly benefit from the use of, the transport of the groundwater in the bed and banks. So that report then recommended to expressly authorize the transport of groundwater using the bed and banks in the watercourse, but would require the TCEQ to evaluate the losses and establish special conditions to promote the reasonable, efficient use of that water. If it's the losses are overly great, then maybe it wouldn't be allowed, or to be allowed only at certain periods of time is what I'm thinking those kinds of conditions would be. And then to change the definition of waste in Chapter 36 to exclude the transport of the groundwater via the bed and banks permit. So in the end, if we left this issue to the courts, there is going to be a winner and loser. And so I think, thinking about legislation is a good idea, to think if we want to have a compromise, because the court isn't going to reach a compromise. The court is going to decide a winner and a loser. And so with that, I don't have any more on that topic.
Well, it's interesting, and I know folks fall all over the map on this issue, and probably most of my clients would consider or do consider putting groundwater into a stream to pull it down the road, downstream waste under Chapter 36 current definition. But the court, I believe, and correct me if I'm wrong, in Pleasanton, the Corpus Christi case said, this isn't really up for us to decide. We can interpret these statutes, of course, but at the end of the day, it's going to be a decision of the legislature. And so we, of course, in working with the legislature, have the power to change this if that's the will of the people. So I think we've had a lot of discussions on that, and we will probably continue to do so.
Yeah, and I think just going back and thinking about a court making the decision, a court is going to look at the state and say, okay, in this county here, you can't put it in the watercourse, but in the very county right next door, you can. And it's waste one place and it's not waste the other, and it's the same aquifer. So, that's what's going to
That's interesting.
Going to be a problem.
Sure.
Right. And I completely agree with both of you. And whereas if we look at it, the legislature, we can provide some clarity to this issue and recognize that there's probably not a one-size-fits-all answer, but if you give permitting to TCQ or something like that, it can be regulated differently around the state based on the conditions where it should be allowed or maybe it shouldn't be allowed.
Great point. So we only have, how many minutes do we have left, Leah? 10. Oh, wow. Okay, great. So we're on time. Great. So we'll...
See how good we are?
I'm shocked. I did talk very fast. So I think we'll move on now to what we're calling our lightning round. We'll each just touch on a couple issues that may or may not be specific to groundwater. But we'll start with you, Madison. What do you got?
Okay, well, back to Middle Pecos, a ton of things going on out there. But this one is really looking at the jurisdiction of P13 wells. And this is an issue that I'm sure you guys have heard about at this conference or other water conferences throughout the year. And when we're looking at this issue, we're asking who has jurisdiction over these P13 wells. P13 wells were drilled initially as oil wells, but at some point were conditioned to be water wells. And so throughout that process, there's been a discussion over, does the Railroad Commission continue to have jurisdiction over these wells since they initially permitted them and they drilled these wells? Or did that jurisdiction transfer at some point to the TCEQ because now it's conditioned as a water well? I don't think we really have an answer. There's, arguments being made on both sides. as someone who represents groundwater conservation districts and works for these clients, the P13 wells are drilled as oil wells. They are permitted as oil wells, so it would make sense that they would continue to be regulated as oil wells and overseen by the Railroad Commission. Alternatively, of course, is it a water well now? At what point does it become a water well? Kind of goes into this jurisdiction. The statute isn't entirely clear. It seems like there's definitely room for argument that the Railroad Commission continues to have jurisdiction, but to really kind of clarify this issue and tighten it up, we would need to go in and specify the definitions of what's considered a oil well, what's considered a water well, and make sure that there's no confusion in between there. You've heard about House Bill 4256 this session. And this bill is really more generally focused at just leaking water wells, and it doesn't really provide context on who has jurisdiction over the specific P13 well.
Thank you. All right, well, for my lightning round, I would like to talk about the Texas versus New Mexico case. I am the Texas chair of the Law of the Rio Grande, and I've been going as a speaker for the past over 10 years. And this case was filed around the time I started going to that conference in 2013. And let me just say that there was always so much tension. And some of y'all in this room have been at that conference between Texas and New Mexico because of this case that was going on. You could truly feel the tension. And most recently, there's been a settlement. It's a proposed decree in that case. And this year, tension gone. We were all friends. It was great. But let me just tell you real quick what's happening there. So that case is interesting because it deals with an interstate compact, the Rio Grande Compact, which determines the allocation of Rio Grande water between Colorado, New Mexico, and Texas. But it's also interesting because it deals with groundwater, surface water interaction. So in this case, under the compact, you have New Mexico is required to deliver a certain amount of water to the Elephant Butte Reservoir, which is about 100 miles upstream of the Texas-New Mexico border. And in 2013, Texas sued New Mexico saying, we are not getting our allocated water under the compact because groundwater pumping in New Mexico below the reservoir, before that water gets to Texas, the pumping is basically taking the water away from the Rio Grande because of surface water groundwater interconnectivity. And so Texas sued New Mexico. New Mexico said, we're not required to deliver anything to the border. It's just to Elephant Butte under the compact. And so that was the issue of what did the compact say. Colorado was a party, United States government was a party, huge years, 10 years of fighting over this deal. Finally, in last fall, there was a sealed proposed decree, which is basically just a settlement between Texas and New Mexico. That was unsealed in January. And the terms of that were finally released, and it was basically, they came to the agreement that New Mexico would deliver a specific amount of water to Texas, and there's a gauge at El Paso measuring that water now. Plus, it determines that if it basically determines how to handle disputes if water is not delivered adequately to Texas. And it's interesting because New Mexico is different, completely different from Texas in how they regulate groundwater. Groundwater and surface water are both owned by the state and issued permits through the prior appropriation doctrine, very generally speaking. So they recognize groundwater, surface water interaction. And it's funny because arguably the same thing is happening just on the other side of the border. The aquifer is the same in Texas, but we don't ever recognize that. But we are requiring New Mexico under this settlement agreement to shut down wells if that surface water on the Rio Grande is not delivered, shut down wells, to buy up water rights. I mean, there's a huge laundry list of things the New Mexico state engineer can do to ensure Texas gets that water and regulating wells in New Mexico. So, so far, the special master, I think it was July 3rd, issued an opinion recommending that the Supreme Court, the United States Supreme Court, who has exclusive jurisdiction, original jurisdiction over this case between states, to basically sign off on this proposed decree. The federal government has issued several is basically protesting this decree. It does not agree with it, but all those arguments are sealed, I believe, at that point, so we haven't been able to review them. So we'll see what the Supreme Court does, but I would imagine they would agree with their special master, which is a federal judge.
Do we still have a little time left?
We do.
Okay. So I'm just going to give kind of the procedural where we stand. We've talked about this LCRA case already a couple of times, but I'm going to give you kind of the procedural where we are so that y'all can follow along with it. LCRA filed a lawsuit against the district in Bastrop County. That the district filed a plea to the jurisdiction. LCRA prevailed on that plea to the jurisdiction, and that the district now has appealed that decision to the Third Court of Appeals. So that's where we stand with that case. It's in briefing. LCRA's brief is due so soon. I'm not in charge. So just follow along with that case because I think it will address some of these exhaustion issues and hopefully give us some clarity on so we're not trying to guess the time and file a bunch of motions for rehearing and everything. So
Finally get to the merits.
oh yeah, the merits.
Does
So
that
we
ever
haven't.
happen?
I don't know if that's ever going to happen. So that's it.
Thank you. Does anybody have any questions? We have a minute or two. I'm sure everyone's ready to go, but we're here for questions.
I don't want to turn down this opportunity for some free legal advice. Look, I was really, really concerned. I think in the middle you were referring to the article that came out about the discharge of the produced water in the creeks and the rivers. I was really concerned that apparently, according to that article, that was already happening in the Eagleford, and the groundwater districts were not notified. And so, as a GM of a groundwater district, what would your recommendation be to somehow compel the TCEQ to let us know if they're going to be allowing companies to discharge in our creeks and our rivers?
So my understanding is, and please, whoever knows more on this issue, feel free to chime in. On the east side of the 98th Meridian, TCEQ has already developed a standard permit for smaller discharges for these like special, what are they called? Like skitter wells, some special kind of wells, but they're just small discharges, okay? Stripper wells, that's right. Stripper, I was close.
Yeah.
But
Skittle, we like
Skittle
Skittles.
wells. So that standard permit, I mean, that's already set in stone, right? But on the western side of the 98th Meridian, that's going to be determined on a case-by-case basis.
Okay.
And if TCEQ, you know, we can talk to them about doing a rulemaking, but that's like a huge ordeal.
Mhm.
I would recommend, you know, hiring a monitoring company that would get notifications of these discharge permits and have them, like we've done with injection wells. My clients have UIC programs and we've hired a company that looks at all these that are filed in their district and notifies us because that's all they do. Okay. So I would probably look into maybe that, but I did read the article you're talking about, and the fact of the matter is we represent river authorities too, and so this is concerning. It's not that it can't be done. It's just that there are a lot of chemicals and substances in these discharges, and we just want to make sure it's done right.
Exactly.
Right?
Exactly. And we can't know if it's being done right if we don't know that it's being done.
Sure.
So one thing I would just recommend is you can go get on the TCEQ's mailing list. You
Okay.
just submit something to the chief clerk and you say, I'd like to be on the mailing list and get all the notices for wastewater or whatever, or I just get all of them for this county or that county.
Yeah.
So you can get on the mailing list that way, and it's pretty
Okay, I
easy.
wasn't aware of that. Okay, I'll do that too.
Yeah.
Okay, thank y'all.
Mhm.